if you want to prevent, in all seriousness, you want to prevent foreign influence in elections, okay? We have foreign influence in our elections, and it's not coming from the right, and it's not redounding to our benefit. It's redounding to the detriment, not of individual elected officials, but of the Constitution. I'm going to tell you how. There's a guy, his name is George Soros. He started his career as a Nazi collaborator in Hungary.
That's right.
And then he went around the world and he was a currency manipulator. That's how he made his billions of dollars. He's a multi-billionaire. He shorted the sterling, the baht, the ruble, the ringgit, the yuan, some of those currencies people maybe not have even heard of. But mark my words, he caused economic misery to hundreds of millions of people in both the developing and in the developed world. He came to New York. He has a massive estate in near Westchester in the Hudson Valley. And from there, he sends millions of dollars into elections in Florida, not only to buy our prosecutors, because he flipped some prosecutor seats a couple of years ago, but he also buys amendments. And so we have a system in you can put a ballot initiative on the docket, and you can completely short circuit separation of powers, bicameralism, presentment to the governor, all of those good things that we have that we learn about in sixth grade civics. You can short circuit that by doing a ballot initiative, and you pay petition gatherers, and then you send out a couple $1 billion worth of mailers right around now in order to influence the outcome. And all you need is 60% on one day of the general electorate. Mm-hmm. There's no, you go through the House, you go through the Senate, you work out a compromise. The staff look at the language. We try to get rid of any loopholes, clarify any issues. There's no opportunity for any stakeholders to make comment. And there's certainly no veto by the governor, review by the court. Well, there is a review by the court, but it's perfunctory. And we don't have the standard checks and balances that we used to have. There's an initiative that I've been supporting for a number of years right now, and it makes it more difficult to amend the Constitution. Remember, the Constitution's a counter-majoritarian document. It protects individual rights, separation of powers, and independent judiciary. We don't want it to be too easy to amend the Constitution. Bad people like Castro, Stalin, Mao, those people were able to amend the Constitution easily to take away individual rights, to violate private property, freedom of religion, things of that nature. We want the Constitution to be robust so that whoever is in power has a check on that power. What Amendment 4 does, this Amendment 4, not the last Amendment 4, the new Amendment 4, 2020 Amendment 4, it says that you have to have consecutive elections where you reach that 60% threshold. So there's more time to vet some of these initiatives that are sometimes funded by these out-of-state special interests.
So are you in favor of Amendment 4?
I'm in favor of Amendment 4 because I love my Constitution. I took an oath to preserve, protect, and defend. I didn't take an oath to amend willy-nilly.
Right.
Okay? And people say that the Democrats or the detractors from this amendment will say, well, it's the will of the people. Well, a lot of things were the will of the people. Plessy versus Ferguson, separate but equal, that was the will of the people. Jim Crow was the will of the people. At one point, slavery was.
Sure.
We had Japanese internment. We had bad things going on well into the 60s that were so-called will of the people. But we don't do those things because they're unconstitutional. And now I hope at least that the will of the people has changed. So it's not just the will of the people. It's, is this the right thing to do? Is this consistent with separation of powers and good government? And if it's the will of the people, then here's my invitation to you. You got 15 days to elect a good legislature, elect a legislature of your liking. Mm-hmm. The fact of the matter is these out-of-state special interests can't win legislative races. So they go and try to do these special interest one-issue ballot amendments because they think it's easier. Things like an assault weapons ban.
Right.
It's not the will of the people. You have reasonable regulations. We have those in Florida already. We just need to enforce them. No felon gun ownership, things of that nature. Those are easy things. But if you're saying it's the will of the people and you can't get it done in the legislature, well, hello. It's because it's not the will of the people.
Yeah.
Because we sit for 2-year terms, so we're very easy to vote out if we're not doing our job.
That's right. You're always running for re-election when you're in the legislature.
And as the Federalist Papers say, right, we're in the lower house. And we are supposed to be the most accountable and most sensitive. And then you have the senators who in the United States senators sit for 6-year terms. They're supposed to be a little more deliberative. Our state senators sit for 4-year terms. Same thing. President, 4 years. Supreme Court, lifetime appointment. So we have some branches of government that sit for longer terms and are more insulated. And then we have some folks who are very sensitive to the needs of the people. And that way we get a consistency, but we're also doing the will of the people. And that was the brilliance of our framers of our Constitution.
Yeah.
And I see that being upset and undermined as we go through, particularly in Florida, where in the federal Constitution, it's a little pamphlet. You can read it in one sitting. You fit it in your breast pocket. The Florida Constitution takes up most of my House of Representatives rule book.
Mm-hmm.
We have our rules. The Florida Constitution is longer. It's essentially a 7th volume of the Florida statutes.
Yeah.
And that's not what it was intended to be. It was supposed to be the DNA of our republic. It's not supposed to be something that spells out everything. That's for legislation. And as you know, some of the big government folks in Washington do, they have that. Then they have a whole code of federal regulations. We have a state code of regulations as well. That's gotten out of hand, but certainly it should be in the statute and not in the Constitution, and if strictly necessary in the regulations. But it kind of saddens me that folks don't understand that, and I think there are well-meaning people on the left, but they don't seem to grasp that kind of fundamental thing that should have been clear to everyone after they took their 6th-year civics class, that we have separation of powers and you legislate in a certain way, and it involves compromise and hard work, and sometimes you bring a bill back and you bring it back again and then you finally get it out off the House floor and it goes to the Senate and it dies there and you bring it back again, and you just keep doing that if you think it's good public policy, and the bill gets better because you make those compromises, you have that back and forth, you have that dialogue, and you spell out each individual circumstance that the courts. The other thing is now people write vague bills and that's their first draft. Now the courts have to go through and try to determine what does this thing mean.
And that's not even the proper role of the court.
That's not the proper role of the courts. When people come into my office and they give me a piece of legislation, either they want me to run the piece of legislation or they want me to support something that someone else has filed. I always look through the legislation. I say, what does this mean? And they say, well, the judge is going to have to figure that out. And these are good lobbyists. I mean, these are intelligent, successful people. And I said, no. Go back to your office. Sometimes it's an issue that I'm agnostic on, but I know that 2 companies are going to be arguing about it, or 2 individuals, or a family, or whoever it is, or a criminal defendant in the state. I say, go back and figure out what you want to do. Come back in. As long as it's good public policy, I'll support that. But you have to spell it out in the statute so that you're not inviting the courts. And before it gets into the courts, remember, it's lawyers like you and me who are trying to counsel our clients to conform their conduct to the law, to know what the law is so that they can plan their personal affairs, their business, conform their conduct to the criminal code as well. Because we have to give notice to the people what the law is, right, so that they can plan accordingly.
That's the rule of law.
That is what the rule of law means. Otherwise, it's rule of man. When you have a judge legislating from the bench, particularly a trial judge, but sometimes appellate court judges, that's not rule of law. That might be ruled by law, or it might be ruled by man, depending upon how egregious, or ruled by woman. Right? We have seen certainly Barbara Pariente. We saw that with her, right? And but the one thing I'll say, at least Barbara Pariente spelled out that thing on the old Amendment 4, and the old Amendment 4, we align with her because she made that explicit when they were vetting that amendment. And what we've done in the Florida legislature is consistent with what John Mills, former Democratic Speaker of the House, Barbara Pariente, liberal justice, what we've done on that amendment is consistent with what they said we should do on the amendment. Yeah. And then once they get it passed, and then they say it means something else, which is exactly why the proper role of legislation is in the legislature.
Thank you for listening to the Morgan Streetman Show. We hope you enjoyed what you heard, and if you did, please click like and subscribe to help us out. And remember that we recommend that you exercise your brain at least once a week.